Yes, Mr. Chair, members of the committee, Senate Bill 40 reduces manufacture of marijuana from a Class A felony to a Class B felony and reduces possession of marijuana from a Class B felony to a Class C felony and makes marijuana the same as other Schedule II controlled substances, declares an emergency and effective upon passage. There is a -1 amendment as well as a -4 amendment that break out even further the different weights and how they would be punished.
All right, we have a number of people who want to give testimony today, and based on the way I'm reading the sign-up sheet, I'm going to ask the following three to come up first. Lee Berger, Gail Meyer, and Daryl, why don't you come up as well? I'll take those three first, and then we'll take the next two. It's my understanding that this is still a work in progress, meaning we do not have a final draft of amendments at this point. And if that's the case, I'd like to have whatever needs to be on the record regarding where we're at, so the committee kind of knows where we're potentially going.
Thank you. Chair Brzezinski, members of the committee, Gail Meyer on behalf of the Criminal Defense Lawyers Association. We initially proffered Senate Bill 40 to do a very simple, technical correction and simply make marijuana crimes reflect the fact that marijuana has now been scheduled a Schedule II drug rather than a Schedule I drug. And so specifically with respect to possession of marijuana of more than an ounce, it would reduce it from a B misdemeanor down to a B felony down to a C felony. That was our bill originally. It's proven to be a good vehicle for the more robust conversation about whether or not there should be a misdemeanor marijuana tier. Because as our current laws stand right now, if you have less than an ounce, it's a violation. If you have more than an ounce, it's a B felony. If you were to take our bill, Senate 40, in its original form, it would be less than an ounce to a C felony. Big jump between a violation and a C felony for possession of marijuana. And many states have a middle tier. The -1 has multiple tiers, and in all candor, that's generated a lot of pushback. And so I think the current debate, Chair Brzezinski, as best as I am informed, it's taking place, is whether or not the appropriate tier, if we were to do just one tier, one misdemeanor tier, should it be at a B misdemeanor level or an A misdemeanor level? OCDLA would highly encourage everyone to start talking about a B misdemeanor as the appropriate level for the tier. And the reason is it's evenly calibrated between a violation and a C felony. A C felony in any event could be declared to be a misdemeanor, in which event it would be an A misdemeanor. So to have your tier at an A misdemeanor would almost be redundant to authority that the court would have in any event. So we think the appropriate level is a B misdemeanor. And with that, we know that interested stakeholders have different thoughts about the appropriate quantity that should be included in that B misdemeanor. Consistent with other states, there's good logic to make it up to 8 ounces. There are those who are uncomfortable with that quantity. So that's the current debate, Mr. Chair.
Mr. Chair, members of the committee, Daryl Fuller on behalf of the Oregon State Sheriff's Association. In consultation with my colleague, we are in support of Senate Bill 40 as a technical fix to an issue, and don't have any problem with that bill. When we start talking about the amendments, I suspect strongly that the sheriffs will oppose any of the amendments in long and in some cases entertaining discussions with sheriffs over shifting possession of larger quantities of marijuana down from a felony to a misdemeanor. A strong contingent of the sheriffs simply don't have any interest in going there at all whatsoever. So we've been a party of group emails that have been going around looking for some middle ground, and we're participating in those to the degree that we're able to do so, but ultimately I suspect that the sheriffs will end up opposing any amendment that degrades the penalty for possessing what we consider to be large amounts of marijuana. I'll be happy to answer any questions you have.
All right, thank you. Lee?
Chair Prozanski, members of the committee, my name is Leland Berger. I'm a lawyer, I'm an OCDLA member, but I'm appearing today on behalf of Compassionate Oregon. OCDLA requested the pre-session filing of Senate Bill 40 at my request, but Compassionate Oregon had developed a proposal regarding some misdemeanor provision. And initially we had recommended that the less than an ounce law for a violation be increased to 4 ounces, consistent with the decision from the Alaska Supreme Court interpreting their privacy provision in their state constitution that permits 4 ounces with no penalty in the home. We had a 3-tiered system because we were recommending 24 ounces as a C felony because that's the amount that OMA patients can possess. It made sense to us in that regard. We're aware of the -1 amendments. We haven't seen the -4 amendments, but I'm assuming that they reflect what Ms. Myers testified to about the 8-ounce cutoff. We agree that in consultation, although not directly with the sheriffs, indirectly with law enforcement as a community, that it makes more sense to have a smaller number than 24 ounces for a C felony, and with that, it makes sense to have a single tier in the misdemeanor level. And to be more precise, and following up on Ms. Myers' testimony, Oregon law provides that, with the exception of sex offenses and domestic violence offenses, that Class C felonies can be reduced either by the prosecutor at charging or by the judge either at sentencing or the completion of the probationary term to an A misdemeanor. And that's why it makes sense to make it a B misdemeanor. In response to the, and then the other thing that was really interesting with the -1 amendments is that it separated out marijuana which is not hashish, from marijuana, which is hashish. And current Oregon law only does that for less than an ounce. It's less than an ounce of marijuana, not hashish. Marijuana hashish is automatically a felony. Our view is that that leaves one of 2 possible interpretations. Either any quantity of marijuana that is hashish can be prosecuted as a violation of the unlawful possession of Schedule II controlled substance, or hashish is legalized. Again, as with the marijuana itself that's not hashish, it doesn't make sense that there isn't a marijuana that is hashish misdemeanor as well. Frankly, it's a concentrate that both is used by patients and recreationally. It involves, because it's a concentration. It's kind of although it's difficult analogizing alcohol to the regulation of alcohol to the regulation of cannabis. It's kind of like the difference between a beer and bourbon. So it's not that it shouldn't be regulated, and it's probably appropriate to regulate it differently. And one place I think where there's broad agreement in terms of reaching a number, both among producers and among those in law enforcement that I've spoken with, is that it's roughly a 4-to-1 ratio. That it takes about 4 ounces of marijuana to produce an ounce of hashish. So our view is that, again, that we should increase the less than an ounce to less than 4 ounces and make 16 ounces a Class C felony, and in between 4 and 16 ounces a B misdemeanor. And for hashish, a quarter of 4 is 1, so less than an ounce of hashish would be a violation. Between an ounce and 4 ounces would be a B misdemeanor, and more than 4 ounces would be a C felony. Now, historically, among law enforcement, the sheriffs have been the most adamant prohibitionists. They refused to issue, you may recall, they refused to issue concealed handgun licenses to patients because they were patients, even though they were rebuffed in the circuit courts in Washington and Jackson County, in the Court of Appeals, and the Supreme Court, and the United States Supreme Court denied cert. But the fact is that tomorrow afternoon, in the House Judiciary Committee, they're going to consider House Bill 3371, that's a legalization proposal. And if it doesn't pass this session, it'll pass at the next electoral cycle or the electoral cycle after that, because when last asked, 47% of the people thought that unlimited possession and unlimited cultivation was okay. That's what happened in Measure 80 last fall. So I think in assigning, as uncomfortable as it may be for the sheriffs and their livelihood, the fact is that we're headed towards legalization, and any numbers that are instituted ought to reflect a glide path towards that. In that respect, tomorrow night, Chair Przanski, the Joint Committee on Public Safety is going to be hearing House Bill 3194, where there's a proposal to increase substantial quantity for the felony sentencing guideline purposes from 150 grams to a kilo, 2.2 pounds, and to reduce the ranking for no prior involvement from a crime severity 8, which is a presumptive prison sentence, to a crime severity 4, which is a presumptive probation sentence. So although in the abstract talking about, between a pound and 4 ounces ought to be a misdemeanor and a pound ought to be a felony seems like a huge increase, it's not in the context of our trying to fashion a glide path towards legalization and taking into account and recognizing what 3194 would do. The Public Safety Commission's recommendation about sentencing guidelines. I know it seems odd to talk about misdemeanor marijuana or misdemeanor hashish, but the fact is that 35 states have misdemeanor marijuana provisions, and 7 states have misdemeanor hashish provisions. Alaska's less than 6 grams, Indiana less than 2 grams, Pennsylvania 8 grams or under, Montana 1 gram, New Hampshire 5 grams or less, North Carolina 1/20th of an ounce or less. In Ohio, they differentiate between a solid form of hashish and the oil, the honey oil. If it's more than 5 grams or less than 10 grams of the solid, it's a misdemeanor. If it's less than 2 grams of the liquid. And I wanted to just let you know what some neighboring states are doing. California actually is similar to Oregon. It's a violation and then it's a felony unless it's a violation within 1,000 feet of the school, and it's a misdemeanor. But Idaho has a misdemeanor provision less than 3 ounces. Washington, which recently legalized, before they legalized it was 40 grams. And those crazy liberals in Utah, it's a misdemeanor if it's less than a pound. So if we were to adopt the proposal, the legislature were to adopt the proposal that Compassionate Oregon is making, it would bring us in line with Utah in terms of misdemeanor possession. So in closing, 2 things. The first thing is, well, I guess 3 things. The first thing is that if we're going to have a misdemeanor proposal, the tier should be there should only be 1 tier. There's widespread agreement on that, and it ought to be at a B for the reasons I've described. The second thing is that Compassionate Oregon is less concerned about what the numbers actually are, but we do think that they should make some sense or have some relevance or have some connection to some reality other than the political reality of what would pass or not pass or whatever. It should be referenced to something. And in that regard, and having the reason for Measure 40 is that there are patients who grow for themselves who have the right number of plants, but some get too tall over the weekend, and they're lodged in a jail on a Class A felony, and they can't be released by the jail, and the bail is twice what it would otherwise be, and that's the reason for an A to a B and a B to a C on the possession charge. It just makes sense, consistent with the rescheduling from Schedule 1 to Schedule 2, and I don't think there's any opposition anywhere to that. And so the last thought I want to leave you with is to please not craft an amendment that's going to jeopardize that core reform, because as modest as it is, it's important and it dramatically affects the lives of real people. So thank you so much.
Thank you. Questions?
Point of clarification, Mr. Chair, I haven't been able to read the dashboard yet, so technology problems, but my understanding is that it would put the misdemeanor 4 ounces.
Yes. I think that
Mr. Chair, if I could inquire, the -4, would that be an A misdemeanor or a B misdemeanor at 4 ounces?
I think I saw it last night, if I remember correctly.
But they just did one here and that was 4.
Could I inquire as well? Does it include since you've separated out in the -1 hashish, that's marijuana, from marijuana that's not hashish, is there also a misdemeanor hashish provision? Or are we just gonna, any amount of hashish is gonna be a B felony?
I think I was focused on marijuana.
Well, I would encourage, Chair Brzezinski, members of the committee, I would encourage you to adopt whatever provision it is that you, whatever number he sees on as a misdemeanor level, below which it's a misdemeanor, 1/4 of that ought to be a misdemeanor for marijuana that's hashish.
Okay. Any other questions? Yeah. Any other questions for this panel? We've got another panel I want to call up. Thank you very much for coming forward.
Thank you.
Our next panel, Katie Schreiber and Steve Buckstein. While they're coming forward, is there anyone else who will want to give testimony on Senate Bill 40? All right. Steve, I think we'll let you go first, and Katie, you'll follow up.
Thank you. Good morning, Chair Brzezinski and members of the committee. I'm Steve Buckstein. I'm Senior Policy Analyst and founder of Cascade Policy Institute in Portland. We're a nonprofit, nonpartisan think tank. I provided you with a commentary that I recently updated that I actually wrote about 10 years ago, titled "Conservatives Should Oppose the War on Drugs." And it applies to people who aren't conservatives. I wrote it for a conservative magazine, that's why the title, and I felt I shouldn't change it. But it's basically an argument why all of us should oppose the war on drugs. And I see SB 40 as a step in that direction. Some of the testimony from the gentleman sitting right here, I think I would definitely agree with. I understand that this bill, as I understand it, this bill simply realigns penalties based on perceived harm. And I thought it included increasing penalties on methamphetamine. I may be wrong, but to the extent that it reduces penalties on use or manufacture of marijuana, I think it's a very good idea. I don't have recommendations as to the specifics because, again, I like the terminology I heard a few minutes ago, a glide path towards legalization. Anything that reduces the penalties, I think, is a good idea. If it includes increasing penalties for some other drugs, I would not think that is such a good idea. As a matter of public policy, I want to make it clear that I don't want the state to support or oppose the use or manufacture of any drug. As a libertarian, I think such decisions should be left up to free adults, not to the state to make those determinations. I hold the same position with regard to alcohol, gambling, and tobacco, which addict the state to their tax revenues as much as they addict addicts or addict their users. This afternoon, I'll be testifying in favor of the bill that again was mentioned here previously, HB 3371, before the House Judiciary Committee, which would be, in effect, legalization. I have some problems with the details, but basically, I think a huge step in the right direction. It is coming, I think, to the extent that your committee can look at this bill in that light. I think that would be good. And any other bills that move us in that direction and end what I think is a disastrous war on drugs in this country will be a good idea. Thank you.
Thank you.
Thank you. Senator Brzezinski, I appreciate it. And members of the committee, my name is Katie Suber. I'm a Deputy District Attorney in Marion County here on behalf of the Oregon District Attorneys Association. The original version of Senate Bill 40, the ODA, does not oppose. Obviously, in 2009, when the legislature directed the Board of Pharmacy to reschedule marijuana, it chose to reschedule marijuana as a Schedule II controlled substance, and this would be consistent with our other drug laws. I have not seen the -1 or -4 amendments, although Mr. Berger was kind enough to show me essentially what the -1 amendments do. And as I understand it, they would effectively insert into the bill different degrees, whether felony or misdemeanor, based on quantities of marijuana. For the better part of my 15 plus years as a prosecutor, I was a narcotics prosecutor. I prosecuted mid and upper level and sometimes street level drug dealers. And I don't necessarily come armed with a lot of statistics, but I come with a lot of experience and a lot of anecdotal evidence. And what that has indicated to me is that most drug offenses, particularly drug delivery charges, are proven by circumstantial evidence. And the biggest circumstantial evidence we look to is the quantity of drug that the person possesses. Is it consistent with personal use, or is it not consistent with personal use? So when we're talking about a person who is found in possession of 8 ounces or half a pound of marijuana, that is not law enforcement or prosecution's opinion consistent with a personal use amount. So these cases are likely going to be charged as delivery of marijuana in any event. What we currently have under Oregon law is a system where a person in possession of more than an ounce of marijuana can be charged with a Class B felony. The court has and will continue to have discretion, regardless of the district attorney's position, to treat that as a misdemeanor up front or at the end of probation, as we sometimes see. And that isn't going to change. Even if a person had a pound of marijuana in their possession and the sole charge for the court's determination was possession of marijuana, the court would have the discretion to treat that as a misdemeanor up front. So what I can tell you is that when we get into differentiating quantities of marijuana, the District Attorneys Association is going to oppose making that differentiation, because as the current law stands, the court has in its discretion the ability to take out of the felony world something and place it in the misdemeanor world. I'll also point out that the amendments, as I understand them, that would create Class B misdemeanors, I think it's important to understand that when a person is convicted of a Class B misdemeanor, that does not reflect anything on their criminal history score if that person was later convicted of a felony. Under those felony sentencing guidelines, the only crimes that count towards calculating a person's criminal history score are Class A misdemeanors or felony crimes. So a person could have, and I'm admittedly being an exaggeration here, a person could have 10 Class B misdemeanor convictions, and it would appear under a felony sentencing guideline charge that they've never had a criminal conviction, because they would be an I on the sentencing guidelines. So I think it's something that the committee should keep in its mind as it considers these amendments and the necessity to have the amendments. I would say that the DA's Association, if the committee wants to consider amendments regarding amounts, we would ask as well that those amendments reflect hash, and specifically quantities of hash, and not just deal with marijuana. I guess the only other comment that I would like to make, if I may, is just sort of in response to Mr. Berger's reference to other states in the United States. Just the states that I heard him list off use gram amounts. You know, I think I heard 6 grams or 1/20th of an ounce as violation amounts. Oregon has long had a policy that a person in possession of less than 1 ounce of marijuana that they are not selling or delivering is guilty of no more than a violation. And that quantity is significantly larger still than other states who require it to be far less. So I believe that Oregon's current policies and laws regarding marijuana are appropriate, and we would oppose any of the current DASH amendments, but the bill in its original form we do not oppose. Thank you.
Thank you. Questions?
Just a curiosity to Mr. Buckstein, I'm wondering if you saw the same Fire and Line program I did, where we opined on the subject years ago, obviously.
Chair Brzezinski, Senator Cruz, I did, but I also knew Bill Buckley a little bit when I was at Oregon State. He came and spoke, and we talked about this. And yeah, he's a conservative icon who, for personal reasons, became opposed to the war on drugs. And I don't think there have to be personal reasons. I think there are policy reasons also.
I mean, this is 30 years ago, something like that. I found it Mr. Chair, the dashboard is online, and the reason I went for 4 is, you know, an ounce of marijuana is not what it was when we were kids. I mean, that's the reality of it. The more I thought about it, having too many steps in this is probably more confusing than not, and I thought that was an appropriate point of departure. So
any other questions or comments? Thank you all very much for coming forward. Again, is there anyone else who'd like to give testimony today on Senate Bill 40? Not seeing anyone, we'll close the public hearing on Senate Bill 40. We're now going to go ahead and open up a public hearing on Senate Bill 80.
You want to say anything before I turn it off, Glenn?
Yes, good night.
Good night. God bless you all, every single one of you.